So there you are. You're fighting deportation, or perhaps not you, but a loved one or a dear friend. And you're trying to see what it is that they need to show so they can remain in the United States. Well, you're in luck. Today's video is just about this. My name is Jorge Molina. I am an immigration attorney based in Dallas-Fort Worth and serving clients worldwide. And we're going to be talking about continuous presence for cancellation and removal today. All right, folks, so we're talking about something very specific here. So let's say a loved one or perhaps yourself or a dear friend ends up in immigration court, and then you know that they're eligible for cancellation or removal, whether they are lawful residents or they're non-lawful residents of the United States. There's different requirements. We've done videos about this that we elaborate on those requirements. But today we're going to focus in one. We're going to be talking about continuous presence. And this is essential because it's one of the elements that you got to show for cancellation of removal for lawful residents or for non-permanent residents. So for lawful residents, you must show 7 years continuous presence in any status. That means whether in lawful permanent resident status or in no status, but you had to be have been admitted in any form of status for that matter. Additionally, for cancellation of removal for non-lawful permanent residents, you need to show continuous presence in the United States for 10 years, right? So 3 more years in lawful permanent residence. And the key for continuous presence is 2 things. So what stops the accrual of continuous presence? So in essence, well, how far back can you look, and how much in advance can you look at after a notice to appear or the immigration court proceedings are started, right? So, and then the other component that's very important at this is, how do you show it? How do you show a court that you have lived continuously for the required amount of time? All right, so let's talk about that first. If you're able to document it through government issued documents, so what I'm talking about here is tax documents, or perhaps you work for the government, or you have some document issued to you by a governmental entity, that is very, very good evidence. Additionally, if you have relatives or children that were born in the United States during that period, that is really, really good evidence. And then you can start looking at other things that are also good evidence. For example, school records, hospital records, or anything showing that you were in the United States and receiving something. So for example, pay stubs tend to be very good evidence. And in case you don't have it, often we can provide testimony to show our continuous presence. But when you're doing that, you need to make sure that you're presenting the case and everything makes sense. So for example, you say, well, you know, I've been living in the United States for 20 years. I've been filing taxes, yada, yada, yada. If you're saying that, you must show that you file taxes. You get to provide your tax returns. If, on the other hand, you're saying, well, you know, I lived here, but I never had formal employment or anything, well, you're going to show where were you living, who were you living with, and why can't you show any other documents? So that's very important. And then the other thing that I would like to review today are the things that stop the accrual of time. So if they start immigration court proceedings and the document that they file with the court is fully completed, that will stop the time, all right? This is known as the stop time rule. More on this in a later video. But importantly here, the NTA, the notice to appear, which starts immigration court proceedings, must be complete and must have the date of the hearing and the location of the hearing. So if it's not fully completed, it will not stop the accrual of time. Additionally, if you commit a crime under a section that is either considered a violation of a controlled substance law, or a crime that is a crime involving moral turpitude, or you have been sentenced to 5 years or more, that would also stop the accrual of time. Additionally, if you left the United States under an order of removal or voluntary departure, or there was a formal way for asking you to leave the United States, that would also stop the time, even though you might come back without, waiting the time that you're supposed to wait. Even if you come back, you would start a new period. So you start from zero when you come back. And finally, any absence from the United States for 90 days or more, or when you add up all your absences and they sum up to greater than 180 days. So, folks, if you have any questions about this, about continuous presence, cancellation or removal, or defending yourself in immigration court, consult a experienced immigration attorney who can guide you on this process. This is complicated. Even if you have the time, you need to show that you have accrued the time. So make sure you talk to someone who is experienced enough to help you. Again, my name is Jorge Molina. Thank you for watching.